this appeal is whether an action against an uninsured motorist carrier for coverage on the insurance policy contract is contract-based or whether it is a personal injury action. If the action is a contract action, then prejudgment interest is allowable. If it's a personal injury action, then under current law, prejudgment interest is not available to the plaintiff. So the question is, what entitles a plaintiff to recover damages from their uninsured motorist carrier? And this question has been answered time and time again in Tennessee jurisprudence. The Tennessee Supreme Court has said it in no uncertain terms that claims against UM carriers are based on a direct contractual relationship between the insured and the insurer. The gravamen of the action does not depend on what the damages are or how they are measured. Instead, the action is on a contract to recover for what are essentially tort damages, but the insurance company is not the tortfeasor, didn't cause the injury to the insured. This court has also said this in no uncertain terms. This court has said the UM carrier does not insure the uninsured motorist, Mr. Vanlier in this case. Instead, it protects the insured against inadequate compensation. And so a suit under the standard uninsured motorist automobile policy is a contract action rather than a personal injury action, even though a prerequisite to recovery is proving the underlying damage caused by the uninsured motorist. Insurance policies in Tennessee are treated just like any other contracts. They are interpreted using contract principles. These 6-year statute of limitations for contract claims apply to actions on uninsured motorist policies just like any other contract claim. They are not governed by the 1-year statute of limitations for personal injury claims. And just like any other contract claim, prejudgment interest is allowable. Since at least 1977, the Tennessee Supreme Court in the Johnson versus Tennessee Farmers case has said that it is settled law that prejudgment interest is allowed on actions for unliquidated damages on insurance policies, including automobile insurance policies, which was at issue in that case. Now, auto owners, the appellee, would now like this court to decide that the claims against it were for personal injuries. But at trial, in its opening statement, auto owners said, and this is paraphrasing in part, while the facts of this case involve a car wreck, the truth is this case is better described as a business dispute between two parties to a contract. This case is about money. And as this court knows, in cases about money due under a contract, prejudgment interest is allowed because the person who is owed that money is denied the loss of use of that money during the time that their claim remains unpaid and the time value of that money, the interest that auto owners in this case earned on that money during the more than 2.5 years that Ms. Haddon's claim was not paid. Ms. Haddon paid premiums for her insurance year after year after year. She paid for this contract so that if she were ever injured by an uninsured motorist, auto owners would pay the damages caused by the uninsured driver. But auto owners did not. And 2.5 years later, we took auto owners to trial, and the jury awarded $320,000. And that award was entered against auto owners as the uninsured motorist carrier. The trial court has already determined that Ms. Haddon cannot be fully compensated in this case if she is not awarded prejudgment interest. However, and with all due respect to the wonderful trial judge in this case, his assessment of the law was that prejudgment interest is not allowed against uninsured motorist carriers in actions involving auto wreck cases. And respectfully, that's because the trial court miscategorized this case as a personal injury action, when in fact it is a contract action. The trial judge relied on cases addressing whether prejudgment interest is allowed in a personal injury case rather than precedent from this court in which the applicability of the prejudgment interest statute to UM actions for coverage on the UM policy has been recognized time and again, most recently in Lewis v. State Farm. As the court is well aware, in Lewis, the jury found that the plaintiff's injuries were caused by an uninsured motorist, and the jury award was $275,000, which was well below the $500,000 policy limit. In this case, the jury award was 100% based on the fault of an uninsured motorist, and the jury award was $320,000. The policy was for $500,000. The trial court in Lewis denied the plaintiff's motion for prejudgment interest on the basis of the contract and a finding of law that the contract with State Farm did not allow for prejudgment interest. This case differs because there's no issue in this case as to whether or not the contract allows for it, but similarly, this case raises a legal issue of whether or not prejudgment interest is allowed to begin with. In Lewis v. State Farm, the Court of Appeals viewed the contract under the lens of the prejudgment interest statute, 47-14-123, and discussed prejudgment interest as an element of damages in an action against an uninsured motorist carrier. Of course, this court overruled or reversed the trial court and sent Lewis v. State Farm back to the trial court for determination of whether or not prejudgment interest was necessary and equitable under the specific facts of the case, and if so, what amount should be awarded. And the case discussed that the uncertainty as to the amount of a plaintiff's claim is not fatal to an award of prejudgment interest, and specifically in that case, an award against an uninsured motorist carrier, and the court cited Myant. Lewis followed other cases of the Court of Appeals, the Malone v. Maddox case and the Thurman v. Harkins case. Those cases both also recognize prejudgment interest as an element of damages, but declined to allow prejudgment interest, finding the court did not abuse its discretion in declining to award interest where that would put the total award against the uninsured motorist carrier above the policy limits. Now, the cases relied on by the trial court and the appellee in their briefing and in the order are not on point. Starting with the appellee's argument that the so-called Wallace rule from the railroad case should apply to UM actions on UM policies. The major distinction is that Wallace, it has not been overturned, but Wallace concerned a tort action for personal injuries by a brakeman against the company for which he worked, common law negligent employment or a safe place to work claim. It did not concern an action on an insurance policy against an insurance company, nor did it concern an award of prejudgment interest on a judgment entered against an insurance company. And the only case that the appellee cited in which this Wallace rule was applied to an award of prejudgment interest against a UM carrier is Keaton v. Klein. With all due respect to this court, I believe the Keaton case was correctly decided, but for the wrong reasons, as I set out in our briefing. But
do we have a split standard of review here? I can envision that we have a question of law as to whether a plaintiff may be entitled to prejudgment interest in an action against a UM carrier. And then, if the answer to that is yes, isn't it a discretionary decision to whether to award it and how much?
Yes, Your Honor.
Okay.
And I think the trial court has already decided that Ms. Haddon should be awarded prejudgment interest, applying the factors set out in Myant. And the only holdup in the trial court, and in fact in the oral, at the hearing, the court invited this appeal. So this would be a great issue for the Court of Appeals because he felt constrained by some middle district Court of Appeals decisions in this case. But yes, the threshold issue is one of law with de novo review, no presumption of correctness.
Now, and I may have myself confused with another case, was Was the trial judge's decision based upon looking at what the law was prior to 1976?
That is the misapplication of the prejudgment interest statute aspect, the error of law, which is that the trial court was looking at Wallace and other cases that look at prejudgment interest in the context of a personal injury action, but did not look at cases that involved prejudgment interest in actions on unliquidated claims on insurance policies.
Okay. So if we're following the theory you want us to, the pre-1976 is irrelevant.
No, it is relevant, but relevant to that is the Johnson versus Tennessee Farmers cases, and there are decades of cases before that where courts do regularly find and affirm awards of prejudgment interest in first-party claims, an insured against their insurer for benefits under a policy, just like a policy. Johnson just happens to be a 1977 case involving an automobile policy. The Keaton case relied on the Hollis case. Hollis also was not an uninsured motorist or even an automobile insurance case. The trial court thought there was coverage on the policy, but the Court of Appeals reversed that ruling and found no coverage. And so then when they looked at the prejudgment interest award, they were looking at prejudgment interest in a wrongful death action, not an insurance claim. There was no applicable insurance. So Keaton relies on that Hollis rule in finding that prejudgment interest was not allowed on an award against a liability insurer and an uninsured motorist carrier. The thing in Keaton is that prejudgment interest would have caused the total award to go over the policy limits anyway, so it was correctly decided, but it shouldn't have relied on that Hollis case because it's not an insurance case. The trial court also relied on the Francois case, same thing, not an insurance case. So we're asking for a reversal of the
Rebuttal. Good morning.
Good morning. Michael Johnson with K. Griffin Evans. We represent the Appellee Auto Owners Insurance Company. Now, neither the prejudgment interest statute nor any of the case law we're looking at here permits the recovery of prejudgment interest in a personal injury case. It sounds like we can all agree on that. And what that means in case law is a case that involves unliquidated damages sounding in tort. That's all the way back to Wallace. That's what we know is the statement of the law. And the prejudgment interest statute says, of course, that interest may be awarded as permitted by the statutory and common laws as of April 1st, 1979. Here, the appellant has not cited a single case, whether from before 1979 or after, that has permitted the recovery of prejudgment interest in a personal injury case. So they are asking the court to make new law, which would be contrary to the prejudgment interest statute and frankly would represent a massive shift in the law in personal injury cases.
Why isn't this, excuse me, why isn't this a contract case?
Because there was no contract claim.
You're claiming under the uninsured motorist contract.
That's right. That is the basis for the plaintiff's claim, of course, in a case.
Right.
But they don't allege a breach of contract claim in a case like this. All of the cases where the court found prejudgment interest appropriate as to an insurance company were either coverage cases, breach of contract on an insurance policy, right, bad faith and the like, or this issue of whether it was permitted in the first place was never raised at all by the parties. So, for instance, in the Lewis versus State Farm case, the plaintiff sued John Doe, someone who fled the scene, nobody knew who it was, and the carrier. And the only issue on appeal was whether the policy included coverage for prejudgment interest. No one made the argument that prejudgment interest was not permitted in that case in the first place. The only issue analyzed was whether it was included in the covered under the policy.
But in this case, aren't you arguing that no matter what happens, your liability cannot exceed $500,000, including the damages award, and if prejudgment interest is permissible, an add-on of prejudgment interest?
That would be correct, yes. 500,000 would be the cap.
And your right to cap that damage is based on contract.
Correct. Correct. And you just heard a little bit about Keaton versus Klein, but that is Exhibit A for auto owner's position in this case. The late Judge Kane decided that case in 2006. He cited that 100-year-old Wallace decision and a more recent decision of this court, the Hollis case, and he observed that prejudgment interest could not, same kind of situation, that prejudgment interest could not be awarded against a UM carrier in a run-of-the-mill personal injury case like this. And critically, our Supreme Court denied permission to appeal in that case, and did not mark it not for citation. So if this were to be taken up by the Supreme Court, we believe that they would agree with Keaton versus Klein based on their denial of that appeal. So now the appellant argues that this should be considered a contract case, not a personal injury case. But this is not a coverage action, like I just mentioned. There's no coverage claim. It is the basis for the claim, and procedurally this court has found in the past that a claim against a UM carrier sounds in contract, right? Based on for procedural purposes, under the statute of limitations, for the purposes of our statutes defining how you sue an insurance carrier in this realm. But in terms of prejudgment interest, no court's ever found that this is anything other than a personal injury case. So, for instance, the Malone case. That was an instance where the carrier was sued in its own name. It was a coverage action. It was not an action like this where a carrier is sued as an unnamed defendant in a personal injury action. Similar thing happened in Thurman. The original plaintiffs, the tortfeasors, all settled out. The court granted the plaintiff's motion for declaratory judgment on whether there was coverage under the policy, and that went up on appeal. That was the issue. It was a coverage issue under Thurman. So none of these cases have ever held that in a, like this, run-of-the-mill car accident case, UM carrier sued as unnamed defendant, that prejudgment interest is appropriate. That's just never been held.
And did any of those cases deal with that specific issue other than the one that you mentioned that Judge Kane, I believe, ruled on in 2006? Did any of them deal with that specific issue here before us today?
They did not. The Keaton versus Klein case that Judge Kane decided is the only one that we were able to find that squarely addressed this issue.
And what was the basis of the reasoning of that holding?
The court cited the Wallace case, which is the original Tennessee Supreme Court case that lays out the rule for prejudgment interest. The railroad case that the appellant was just talking about. And it says, you know, here are the cases where we award prejudgment interest when the claim is liquidated. So property damage case in which an insurance carrier is sued, right? Let's say house burns down, insurance carrier is sued. We know the damages more or less from the beginning, right? Or they're ascertainable. And then they contrasted that with personal injury cases like the one that was before the Supreme Court in Wallace and said, you know, generally in personal injury cases, these claims are not going to be liquidated. And they wouldn't be appropriate for an award of prejudgment interest. And so the Wallace case laid out that test and said not appropriate in personal injury cases. And then the Hollis decision said the same thing, Tennessee Court of Appeals from a couple years prior to the Keaton versus Klein case. And Judge Kane set out those decisions and he said, you know, this is a personal injury case. UM carrier is being sued as an unnamed defendant in a tort case. And I'm bound by Wallace. And he also pointed out that Hollis was published at the direction of our Supreme Court. And so he was bound by Hollis as well because that was essentially the judgment of the Tennessee Supreme Court. So his reasoning, in our view, is on all fours with what we're dealing with here. And again, our Supreme Court denied permission to appeal, so it seems to us that they're likely to do the same thing here if you know, we end up having to go up there. Now, as I mentioned, of course, prejudgment interest is permitted in a direct action against an insurance company, right? Insurance company is sued for coverage. In most of those cases, prejudgment interest. But in a case like this, where we've got unliquidated damages, personal injury case, unnamed defendant, it's simply not permitted and never has been in cases like this. So if there's no further questions, that's all I have.
Hearing none, thank you, Mr. Johnson.
Thank you.
Rebuttal by Ms. Baker.
The statute in Tennessee says that in order to make a claim for the contractual coverage of your uninsured motorist policy, you must follow the procedure set out in that statute to make the carrier a party defendant to the case. Now, they have an advantage. You can't name them by name, but it does not make it any less a direct action against an uninsured motorist carrier. It's how you access the coverage. It's mandated by law. And to say that because the insurance company can't be named directly unless they so choose to reveal themselves to a jury should treat interest under that policy any differently than any other contract is unfair and would lead to different treatment of different plaintiffs. And frankly, it violates the public policy behind the prejudgment interest, which is to compensate someone who paid for a contract to pay for damages when an uninsured motorist causes them. I wanted to revisit the Keaton case. Counsel argued that the Tennessee Supreme Court denied cert. Respectfully, there are many reasons that the Tennessee Supreme Court might do that. One such reason could be that it wasn't a wrong result. There's no reason for the court to take it up and attack reasoning if it does not disagree with the result. I could not find any Tennessee appellate court opinions that even cite to Keaton. Notably, the Lewis v. State Farm case doesn't cite to Keaton. It's an outlier. I do not think it should determine this case, and it's an unpublished decision. And again, in Keaton, which is the only case where Wallace or Hollis are ever applied to an insurance case, a case, in that Hollis case, the court recognized its decision was contrary to Myant versus Allstate, the Tennessee Supreme Court case on prejudgment interest on an auto insurance policy. Thank you.
All right, thank you, Ms. Baker and Mr. Johnson, for your arguments. We'll take your case under advisement, and that concludes the morning docket.